Welcome to The Explainer. Today, we're getting into the essentials of estate planning. Let's do it.
So what happens to your stuff when you die? It's a tough question, but super important.
See, if you don't have a plan, the state actually has one for you already.
A whopping 67% of Americans don't have a will. They're just letting the state decide.
The legal term for this is intestacy. It follows a really strict family tree.
And that state plan, it almost always means going through a public court process called probate. Okay, so what does probate actually mean for your family? Let's break this down. First off, time. We're talking a year, maybe even a year and a half. It's long. Next up, the cost. Legal and court fees can chew up 3 to 7%. And get this, privacy goes out the window. Your family's business becomes public record. And if you're not married, your partner of 15 years could get absolutely nothing. Seriously.
So how do you take back control? Well, the first step for many is a will.
With a will, you decide who gets your assets and who cares for your kids.
But here's the catch, and it's a big one. A will does not avoid probate.
Think of it like this. A will is just your personal instruction manual for the court. To bypass probate entirely, a lot of people use something called a revocable living trust. Basically, you transfer assets to a trustee who manages them for your beneficiaries, no court involved. A will is basically a letter to the court. A trust, it's like a box for your assets.
And that's the whole point, right?
Getting your ducks in a row for your loved ones.
So let's put them head to head. The biggest difference, by far, is avoiding probate. See?
All right, key takeaways. Do nothing, and the state's in charge. A will gives you a voice.
But a trust bypasses probate entirely, keeping everything private and saving a ton of time. So you have to ask yourself, what do you want your legacy to be? A public court case or a private matter?